may vary.
The minimum demand does not vary.
Yes, but the second component is based on the customer's demand.
It's based on the rate schedule minimum demand, which does not vary. It's fixed in a rate schedule. It will remain that until the rate schedule is updated in a subsequent rate case.
So the minimum monthly charge does not have a component based on the customer's demand?
It has a component based on the rate schedule minimum demand.
All right. And you had discussed earlier when you were describing the workshop process about discussing the community solar law, correct? And you're familiar with the community solar statute?
Yes, I'm certainly not a lawyer, but I have read that many times.
All right, I'm going to ask a question about some ambiguity that has arisen. So part of the Community Solar Act at 62(6)(b)(7)(b)(8) requires that community solar bill credit be derived from the qualifying utility's total aggregate retail rate on a per customer class basis, less the commission approved distribution cost components. So it's defined in the community solar statute. Goes on, the total aggregate retail rate is defined as, well, in 62(16)(b)(2)(o), paragraph O.
Hearing examiner, may I just confirm that Mr. Settlage has a copy of the statute, so he's not trying to do this from memory since Mr. Black's not sharing his screen. Do you have a copy?
I do have a copy in front of me. Could you tell me the exact location again, Mr. Black?
Oh, yes, it's in section 2 of the, it's 62(16)(b), section 2, paragraph O, or subsection O.
Okay, I'm there. Yes, sorry. I'm with you.
Yeah, and that's where the total aggregate retail rate is defined.
Yes, I see that.
Okay. Okay, here's the question. Given that PNM's minimum monthly charge for classes that the company has proposed to exclude minimum monthly charges from given that PNM's minimum monthly charge is described as a minimum monthly charge, but is a part of PNM's demand, energy, and other charges, wouldn't you agree that the law is unclear, or whether, or maybe this component should be excluded from the calculation of community solar bill credit rates?
Objection, hearing examiner. I don't disagree that Mr. Settlage needs to be familiar with the statute in order to carry out his duties. But what Mr. Black is asking about ambiguity in the statute seems to be much more of a briefing issue, a legal issue, and not something for a technical expert like Mr. Settlage.
I agree with the objection. The witness can state his opinion. He's already stated that he's not an attorney. If he wishes to express his opinion on it, he can, but I understand that this is a briefing. When it comes to statutory interpretation, it's more of a briefing issue. But witness can answer if he would elect to.
I don't see it as a conflict in my mind. I don't see it as any different as the customer charge. Customer charges are included in those things as well, the categories you called in some way, and they're excluded just like this. So I don't see an ambiguity. I don't see a difference.
All right, thank you. And thank you, counsel, your counsel. Let me switch issues a little bit here. I'm looking at PNM Exhibit 6, page 7, beginning at line 17, moving on to page 8, going to line 3.
Yes.
And that's it's regarding customer experience advisors and revenue support representatives.
Yes.
Okay. At the time that when PNM plans to phase in these additional staff members, Will P&M be submitting documentation justifying that need for additional support?
I believe we will. I think P&M witness Contreras could better answer that question, but we expect to. So you're talking about basically administrative cost rider, which is rider number 57. And our proposal there is we've got to have a rider to start. We want that rider to start as soon as the community solar program starts. Subscribers will have some charge from the very beginning based on their amount of energy they're receiving from community solar. What we propose is once a year, or every 12 months, whatever you want to call it, we'll do an update to that where we'll look at actual costs, actual expenses, and true that up, and also project forward what they might be. So our original costs are what we think it will take, but we will review that and see if that's appropriate and submit that for approval to the commission on an annual basis to make sure they agree that those are the appropriate costs to be recovered.
Okay, and so annually will be, you pick a date every year to do it, or I'm not sure if the rule says.
I don't think the rule is clear on that. P&M's intention is to, once we get a subscriber and this starts, let that essentially create an anniversary date. And then on that anniversary, a few months after that, once we've collected the data and looked at what the actual costs and compared that to projected costs, we can do that calculation. So we would see it happening once a year, but we don't know exactly what month or day that will be until we get subscribers.
Okay, and assuming that that date is set and the program's up and running and that anniversary date is set, will that documentation about the need for the additional personnel be contemporaneous, or we'll have to wait for a year?
No. We expect to file an advice notice along with testimony anytime we are doing this true up.
All right, thank you. And then here we go. Here's the zinger. And you can say what you know, or if you don't know. Generally, if you know, when does P&M intend to file its next rate case?
I can't. I can read the paper, and that would be as good as a guess as I could have.
You can't blame me for trying. Thank you. All done. Thank you, hearing examiner. Thank you, Mr. Setledge.
Thank you.
Thank you, Mr. Black. All right, we are at 11:55. And for purposes of those who are watching in YouTube land, I believe we had a temporary disruption due to a YouTube glitch, but that should be fixed, should be back up and running. So hopefully we won't encounter any more glitches this afternoon. Madam Court Reporter, I know we went a little acronym crazy in the middle. Are there any acronyms that you need clarification on?
No, thank you, Mr. Hearing Examiner.
Okay. Jane, you have your hand raised?
Yes, Mr. Hearing Examiner, my two client representatives are telling me that the YouTube link went from a live feed to a pre-recorded video of the length 2 hours and 37 minutes. I would say my clients are pretty tech savvy, so I would respectfully ask that this be looked at.
Okay, I'm getting other messages that other people, I think the first part is that recorded, but I think there is now another live link. But I will, during the lunch break here, I'll work with IT to make sure that we have, the live feed. I think someone indicated we're like on a delay, so it must be a YouTube issue, but I'll work during lunchtime to make sure we have an accurate feed going. And when we come back, Ms. Yee, we will start with your cross-examination questions, which will be the final cross-examination questions for this witness. So we're keeping on schedule, which is terrific, to get us through this afternoon.
Thank you.
All right, everyone, we will take a break, our lunch break, and we will resume at 1 o'clock.
Hello.
Okay, I have 1 o'clock on my phone, so let's get everyone back.
Hearing examiner, I have a preliminary matter that maybe we could talk about before Miss Yee starts. Oh,
On the
Sure.
record,
yes, it would be, I would prefer it to be on the record.
Okay, Allison, we're ready to go. Okay, let's go on the record.
Yeah, Mr. Hearing Examiner, we just wanted to, as we were thinking about Mr. Sitledge's testimony, as you know, P&M's rate case, there was a final order issued just a while ago. We filed our compliance advice notice. Staff signed off on that. And, as a result of that, the bill credits change. And so we're wondering if the commission would like either as an illustrative filing for the parties. We want to be fair and make sure, for the purposes of the record, that parties know what the new bill credit will be based on approved rates. If that's something you would like us, like a bench request, to perhaps provide you with what the new bill credit would be based on newly approved rates.
Okay, let me think about that for a little bit. Because we can either do it that way, or I can ask that it be part of briefing. Because I will allow response briefing as well for this particular case. So let me dwell on that a little bit, and I'll either give you a response before we conclude this afternoon, or when we begin tomorrow, which way. But I see that resulted in all kinds of hands going up. Ms. Yee, I'll take Ms. Yee first.
Thank you, Mr. Hearing Examiner. As it turns out, the questions that NMPEC have for Mr. Sutherland actually touch on that issue that Ms. Terwilliger brought up. And I would say, in response to what Ms. Terwilliger is proposing, that this case had this case took place when it did, based on the kind of regulatory timeline that this case was on, and it didn't necessarily match up with the rate case. However, NMPEC believes that the evidence that was elicited from P&M during this the development of this case is relevant. And I'm kind of arguing and maybe in anticipation, but you will see that we will have exhibits that we do want to submit, and that they should not be struck because of the kind of way the timelines fell, because they have their own demonstrative and substantive value.
I understand. I don't think I'm going to strike anything per se. So to that regard, I don't expect, any exhibits to change. I think what Ms. Terwilliger is suggesting is, a demonstration of how they feel the new credits will, what it looks like under the new order, which clearly is what would go into effect, essentially. Jacob, your question before I go any further?
I was just hoping to respond to Ms. Terwilliger's request.
Go ahead.
Thank you. So I think that there are a number of methodological decisions that the commission is going to be making in this proceeding that will determine what P&M's final bill credit rate looks like. So I understand that there are technical reasons why their proposal might need to be updated to reflect the recent rate case, but I just want it to be clear that that's still their proposal, and after the commission makes its decision in this proceeding on a bunch of methodologies, including how those most recent rates are indexed, as described in Mr. Barnes' testimony. I think, unless the commission approves every request that PNM made, they're going to have to make a compliance filing after this hearing, or probably, or after the decision, most likely. So I guess I like your idea of putting it in briefing, because it seems like a position rather than a necessarily correct representation of what those bill credits will be.
Yeah, and I'm agreed to this. I mean, we're really dealing with methodology and not numbers right now. But Mr. Rilliger, obviously, that's a demonstration of what those numbers would look like. I don't, whether or not that's really going to affect the methodology. That to me would probably not, but it would at least help us visualize it. So I think, let me ask you this, Mr. Rilliger. How long would it take you to put that together?
I believe Mr. Sutledge has already, done most of those, if not all of those calculations. Maybe he could weigh in. I mean, we're not trying to file a change to respond to Mr. Schlesinger. It's not, we understand there are other issues about the methodology for collecting the bill credit that are still at issue in this proceeding. We're doing this solely in the name of transparency. We're trying to be as transparent as possible given the new rate case, and because part of Mr. Sutledge's exhibits have been illustrative calculations of the bill credit under our proposal, because the rate case does change that. We thought it might be appropriate for you all to see that. If you want to just, if folks don't want to see that until the brief, or if the hearing examiner, you want to wait till the brief and they just deal with it in response brief, that's totally fine. We can do that. We're doing this in the name of transparency solely. So.
Okay. I think at this stage of the game, it'll be fine to handle it in briefing. I don't think I need an individual bench request order to go out. I mean, I understand, like I said, the demonstration of here's what we feel the new numbers will look like. But we are really going over methodology, and so I think right now I'm probably going to lean toward just asking you to put that into briefing, because I will allow response briefing, so that'll give the parties a chance to review that, and essentially if they find something incorrect that it differs from the original proposal, I'm sure they'll point it out. So I think I'll just end. I was going to say this to the end of today, but obviously tomorrow I'll discuss at the conclusion. I'll discuss briefing with anybody. Parties should be prepared to ask for any briefing extensions. I know everyone's pretty busy right now, but I'll ask that at that time if any of the parties request an extension for briefing based on that. But let's consider that a briefing issue, and I think that's the best way to go about it right now. And I would expect that obviously to be in the primary brief and not in a response brief. And that to me allows the other parties to take a look at it. Let me know if they feel anything got changed in consideration of that. Anastasia, you have your hand up?
Yeah, I'm just wondering, Mr. Hearing Examiner, and this probably applies if it were done in a bench request response, but this information that they're going to put in a brief is not going to be evidence, right? It's just going to be some sort of demonstration.
Yeah, I mean, that's what I'm saying. I consider a demonstration of here's the sample, here's the sample of what these numbers would look like with this methodology. To that, and that's why I'm trying to draw the comparison where, what we're dealing with is methodologies, not signing off on numbers per se. So, I think what Mr. Rilliger is offering is an example, not the concrete numbers. Because that won't be determined until we devise the methodology, sign off on the methodology. I mean, really, the only thing I'm struggling with is if Mr. Williger can turn this out in a week, it gives the parties more time with it instead of waiting the 20 days after or whatever, after the transcript to look at it. So if the parties want to look at that I guess my question to the parties is, if you want more time with it, it sounds like P&M can turn this out in fairly quick order, so you have time to review it prior to briefing. If you want to wait until P&M puts it into their briefing, that's fine as well. My preference would be for briefing, because I consider this a demonstration only. I don't feel the parties need extra time with it. But if any party feels strongly one way or the other, I'll be happy to entertain that. Okay, we're going to keep it on brief. Hearing no further argument, we're going to keep it as, put it into the primary briefing. And if anyone, after thinking about that, has any other comments to make, I'll entertain those at the beginning of the session tomorrow. But
Mr. Hearing Examiner,
yes, Anastasia.
I'm just trying to put this into a framework in my mind. Does this become like a reconciliation statement in a rate case? And does it imply that everybody has a burden to do that as part of their business? This is probably a question to, something to put on the discussion tomorrow. I'm thinking the answer is no, but that thought just popped into my head.
I would concur with your assessment that does not place a burden on other parties to do the same thing. To the extent that you look at the numbers in the primary briefing and, have an alternate view, that can go into your response briefing, but it's certainly not something I'm asking everyone to demonstrate.
Thank you. Thank you. Thank you. Thank you very much.
Jacob.
Thank you. I just had a suggestion. Maybe some of Ms. Stevens' concerns could be alleviated if, any new numbers are accompanied by, work papers, Excel spreadsheets with formula intact, so people can see how they were derived. Just a suggestion. I'm somewhat indifferent, but thought I'd offer it.
Okay, so probably something similar to the example that we're talking about earlier today that contained some of the, what square B6 where this, if there's any confusion as to how that number was derived, it contains the formulation.
Oh,
Okay.
I'm just referring to standard work papers that are typically delivered in a rate case that just show the Excel files on how the numbers were derived.
Okay. I will, that'll be part of my briefing order then for supplying that. All right, let's continue. We have a busy afternoon, and let's finish off Mr. Settlage first. Remaining cross-exam is Miss Yee. So Miss Yee, please proceed with your cross-examination.
Thank you, Mr. Hearing Examiner, and good afternoon, Mr. Settlage.
Good afternoon.
My name is Jane Yee, and I represent the New Mexico People's Energy Co-op. It's nice to see you again.
Nice to see you as well.
So I'm going to start my questions with reference to your direct testimony on pages 15 and 16.
I have those in front of me.
Okay, and I'm just going to set the table here a little bit, so I'm not going to share screen or do anything like that. I just want to kind of establish what I'm going to be talking about, which is sample bills. Your direct testimony in this area revolves around a couple of, well, it's one sample bill, right? Mr. Sedlich, is that correct?
Yes, I believe the section you're referring to is a sample bill, an example bill, I would say, as opposed to a
Okay,
sample.
example bill. I wasn't sure if I should say example bill, but I'll use that because that's how you framed it.
Would you like me
So-
to explain why I think there's a difference between an example and a sample?
Sure, go ahead. I have 30 minutes.
Well, I promise I'll be very brief.
Okay,
I don't want to use up your time. So the
Okay.
example bill that you're referring to in my direct testimony was trying to illustrate how the calculations would work so that the math was shown appropriately. As opposed to a sample bill, which was intended, which we later provided once we had developed that farther, we later provided sample bills, which are intended to look more like the bill a customer would actually get. The billing system has not yet been updated to even do the bill, so we still don't know exactly how they're going to, what the presentation will be. But the example bills are definitely not, were never attempted to be the presentation customers would see. The sample bills that I provided are much closer to what we think the final presentation will be.
okay. Well, you're very meticulous. I know that from before. So if I could try and summarize what you just said. So you're saying that, for example, in rate cases, when you have sample bills attached to a notice or something, that would be a fair replica of what a consumer would expect to receive if the rates were approved, right? Because all the methodology pretty much has been decided in a rate case. Is that what you're saying? The difference, so that in a sample bill, it would replicate what a customer would expect, whereas in your direct testimony in this case, you're really showing more methodology, right?
I think that's a reasonably fair characterization, yes. We've never had a community solar bill, so it's not just a simple matter of updating rates in the billing system and make this come out.
Yeah.
Whereas in
No,
a rate case, if we're just changing rates for 1A, we've already got examples of that, so it's very simple to come up with a very
Sure.
accurate sample bill.
sure, I'm sorry. Sure. Okay, so now looking at page 15, again, setting the table here, or setting the table for the conversation. 15, page 15 shows the consumption section of the customer bill, or the methodology that PNM would adopt in reflecting the consumption of a community solar consumer, right? Is that what 15 is showing?
Yes, that I think what you're referring to is at the top of page 16. Yes, that section is an example of the calculations for the consumption part of the bill.
Okay, and I know in your testimony you have testified about block charges, and the block charges are reflected in this example bill, right? Example bill, right?
Yes, that's correct.
And
Yes.
so the concept behind block charges, or the regulatory objective behind block charges is to charge customers more if they use more, right?
That is inherent in our inclining block rate design that's currently approved by the commission. Yes.
Yes. It doesn't have to be that way, but that's the way PNM's rates work, right?
That's the currently approved rates. Yes.
Yes. It seems your visual is freezing, but your audio is fine.
I've noticed the same thing. I just wanted to mention that the audio seems to be fine, but many times the video is frozen for periods of time. I wasn't sure if
Yeah,
others
I've
were
just gotta
experiencing that
notice
as well.
Yeah, I just got a note that said the interconnection is unstable, or that, not the interconnection, the connection is unstable. So I don't know if we're having some internet problems, but
Anyway, but going back to setting the table here for this conversation, I'll try and step it up, be a little more efficient here. On this page 15, this is essentially showing a bill, or how a bill would look if a customer, any customer, right? It wouldn't have to be a community solar customer. Any customer's residential customer is going to have a bill profile pretty much resembling what you have put on page 15, right?
That's correct. There's not intended to be any difference from a current bill on that page, with the
That's
single
right.
exception of adding a single line item for Rider 57. But there's
Yes.
no intention to show a change in any calculation.
Okay, thank you, Mr. Settlage. And then on page 16, this is where we get to the community solar part. And this is the whole idea of a bill credit, right? So under the Community
Correct.
Solar Act, PNM is one of its obligations as a qualifying utility is to purchase the energy from community solar facilities, correct?
It's not exactly to purchase. We receive the energy from them, and based on subscriptions provided by the subscriber organization to subscribers, we provide a bill credit to subscribers. But technically, I don't think we're purchasing any energy from community
Okay.
solar facilities unless it gets to that 12-month vintage, and then we cash them out, so to speak, if they have not been able to apply that to a subscriber.
Well, you are so meticulous. I will not do that again. I'm not going to paraphrase a statute. I'm going to read from it. And it says a qualifying utility shall acquire the entire output of a community solar facility connected to its distribution system. Would you agree with that? I'm reading from
Yes.
this. That's correct, right? And so
Yes.
this section is showing the credits that a community solar customer would get based on the amount of the subscription, right?
Yes.
And the amount of the subscription, meaning the amount of kilowatt hours that are allocated to a particular customer, correct?
Yes.
And then, there will be credits given for the energy. And we've gone through a lot of testimony today and yesterday about what a base bill credit is. And then there's a line for fuel and power cost adjustment and for renewable energy attributes. So is that a fair summary of
Yes,
page
ma'am.
16, right? So then I would like to direct your attention to Brian P. Norton's testimony, his direct testimony on page 4.
One moment, please. You said page 4?
Yes.
I'm there. Thank you.
And this testimony has already been admitted into evidence. And on page 4, Dr. Norton is testifying about some discovery that New Mexico People's Energy Co-op served on PNM, and particularly about interrogatory 1.2, in which Dr. Norton had asked PNM to provide 2 sets of monthly bills for an entire year. Do you remember that interrogatory?
Yes, I do.
And Mr. I'm sorry, I'm a little out of practice. Dr. Norton asked that this sets of monthly bill show in one set the current rates, and in another set, a second set, the proposed rates under the rate case that was then pending in 22-270. Do you remember how NMPEC asked for those example bills?
Yes.
And then Dr. Norton testified that PNM transposed the values for consumption and subscription, which are those values are relevant based on what we just went over in your testimony, right?
That's correct.
And Dr. Naughton pointed out in his testimony that there was an incorrect transposition of the values, correct?
That's correct. And I believe we responded correcting
Yes.
that error that we made.
Thank you. Thank you. You're helping me ask these questions more quickly, maybe. And so my next question was, then P&M submitted supplemental responses on November 20th.
Yes, that's correct.
2023. Your Honor, I would like to share screen now, if I may.
Okay, give me 1 sec to make you co-host. Okay, you should be able to share your screen.
Okay, Mr. Settlage, I'm showing you what has been marked for identification purposes, NMPEC Exhibit 7. P&M Supplemental Answers, Attachment A, dated November 20th, 2023. And I don't have exhibit stickers at my house, so I just wrote them on there, but I was very careful marking this and also matching the label next to it, which is your doing, right? P&M's labeling, the typewritten label, right?
That appears to be P&M's labeling, yes.
Okay, so do you recognize this, Mr. Settlage?
I do.
And shall I scroll down so you can see the whole thing? This is
You don't need to scroll down. I take your word for it. When we look at a specific one, we can drill in on that one if that's fine with you.
Okay, so do you recognize this?
Yes, I do.
Did you prepare this?
I certainly did.
And is this a true and accurate facsimile of what you prepared and served as answer to NMPEC Interrogatory 1.1-2?
I believe it is, yes.
Your Honor, I would move for the admission of NMPEC Exhibit let's see, this is exhibit 7 into evidence.
Request is for NMPEC Exhibit 7 to be admitted. Any objection?
I mean, my only concern is this is not accompanied by the corresponding discovery response. I mean, I guess the record is clear enough what this is. I'm not fully objecting to it. It would be better if we had this. The exhibit itself was NMPC, the response to NMPC 1-2 with this attachment, so that it was just super clear for the record. I guess I leave it up to you, hearing examiner, because it's your record.
Okay, I'll note that it's an incomplete record, that it just contains the billing, but I'll admit it and give it the weight that it's due.
Well, I think that Mr. Williger is anticipating or remarking on my little bit of ineptness and admitting these, because I did intend to admit the other one too. And so let me see if I can, and part of this is, I always get nervous with sharing screen. I don't know why, because I've done it a lot, but I still get nervous. And here it is. Can you see this, Mr. Settlage?
So that looks like that is the response to that interrogatory. Can you go to the very top so I can see what it says?
So let me frame it correctly. NMPE, this is NMP, this is a document that is marked for identification purposes. NMPEC Exhibit 6, P&M supplemental answers on November 20th. And then I'm going to scroll down so that we can show the hearing examiner the actual question and the premise for the attachment, and that was my error. I'm saying it's related to the share screen because when I started sharing screen, I saw the first thing, the attachment A first, and so I just said, "Oh wow, here it is. I better pop it in there."
So
But,
to the extent that NMPEC Exhibit 6 contains is the first part of the full interrogatories and request for production combined with NMPEC Exhibit 7, any objection P&M with that notation that they are essentially the same being admitted onto the record?
No objection.
Okay.
thank you.
NMPEC Exhibit 6 and 7 are admitted.
And then finally, I'm going to show you what's been marked NMPEC 8. And this is P&M supplemental answers to NMPEC 1-2, interrogatory 1-2 that was served on November 20th as attachment B. Now, do you recognize this, Mr. Selledge?
Yes, that looks like the exhibit we provided you.
And by the way, these are in the Dropbox, but I'm showing these on the screen now for your easy reference. All right, so now did you prepare this attachment B as part of P&M's response to an NMPEC interrogatory 1-2?
Yes.
And just so this thing is still somewhat coherent, this attachment B shows an example bill with the projected rate after the conclusion of the rate case, the last rate case, right?
This shows with the rates that P&M had proposed in that rate case. Those are not the ultimate rates that were approved in the final order, but at the time, this is what we thought would be in there.
Okay. And I don't think we'll need to belabor it, but I'll ask you a question about that. Right now, I just want to get this into evidence, and with those questions, I do, Your Honor, motion for the admission of NMPEC Exhibit 8 into the evidentiary record.
Request is for NMPEC Exhibit 8 to be admitted. Any objection?
No objection.
It is admitted.
Okay, I'm going to close the screen right now of the sharing. I want to ask a simple question, Mr. Sutledge. There was testimony about the administrative fee and how it is applied on a bill. Do you remember that?
Yes, I do.
And so your testimony, Mr. Sutledge, was that the administrative fee is applied on community solar bills on a per kilowatt hour basis, correct?
It is on a per kilowatt hour basis. It's on the kilowatt hours that they're receiving of community solar.
Okay, and that's exactly what I wanted to confirm. So that if in this case, in the example that we asked P&M to provide, that to NMPEC asked P&M to provide, it was based on 100% subscription, meaning that the community solar consumer was subscribed to its to usage that matched 100% of its average annual consumption, right? That's what NMPEC asked you for. example based on 100%
I just
subscription.
want to clarify, yes, absolutely. I want to clarify that that was on an annual basis. So each of these months, the consumption and the subscription won't necessarily match. But if you add up the 12 months of consumption and compare that to the 12 months of subscription, they should match and be the same number or within rounding.
Yeah. And and my question did, long-winded as it was, it did incorporate the term average annual consumption. And I use that term because it's in the statute, right, Mr. Sedlich? That is the terminology used in the Consumer Solar Act, average annual consumption, correct?
I've seen that term in the act, yes.
Okay. So then going back to my question, the administrative fee being calculated on a kilowatt hour, on the kilowatt hours that are allocated to that community solar customer. If I'm asking if the customer subscribes to less than 100%, then the administrative fee would only go to the kilowatt hours that the customer is subscribing to, not the whole bill, right? Not the whole energy that bill represents, right?
I'll clarify and say it is applied to whatever the community solar energy they receive on that particular bill, regardless of their consumption in that month on that bill.
Okay, so okay, so are you saying then that when that under the administrative rate rider that I'm sorry, would you repeat what you just said?
Yes.
What did you just say?
I'll try to explain it slightly differently, and maybe this will be more illustrative. So the community solar administrative fee line item, the dollars are the product of the community solar subscription energy that they've got multiplied by that administrative fee rate. So the product of those two values gives us the dollars that are shown on that line in the dollar column to the far right on a bill. And has no, I'm sorry, I was just going to clarify further that it is not related to the upper consumption part of the bill. It's related to the bottom or the middle, whatever you want to call it, community solar credit portion of the bill.
All right, so is this in your direct testimony?
In my direct testimony, I go through an example explaining this is that, using the phrase example, bill to describe how that is calculated. Yes, it points out that that charge, the community solar administrative fee charge, the dollar amount, is based on the community solar energy the customer gets multiplied by the fee rate, which is $1 per kWh rate.
All right, thank you. All right, so rather than venturing into the share screen again, I'm going to ask you whether you can testify without looking at the example bills, whether there was carryover in the months of February, March, August, September, October, and November of the attachment A, which goes to the example based on the rates that were effective at the time you answered this question. I wonder if I should share screen, or do you want to just refer to it? Maybe I want to be cognizant, or I want to honor the hearing examiner's wish to keep this moving. So are you able to answer that question with what you have in front of you?
Yes, I see that based on that response, we give the 1-2A supplemental that in the months of March and April, and I'm looking at them one at a time. September. I'm sorry, I'm reading those wrong. I apologize. Let me start over. In the months of
I think in February.
February, yes. February, there's a
February.
73 cents. March, there's a credit as well, a net credit. In April, there is not. Looking for more credits.
August,
Yes, August has a credit. Yes.
September,
Yes.
October,
Yes.
November.
Yes, I agree.
So we have 1, 2, 3, 4, 5, 6 months of where there was a credit, meaning that there was amount carried over to the next month, correct?
Correct.
And at the end of the year in December of your set of example bills, 2023, December of 2023, under the then existing rates, there was no carryover, right?
That is correct.
For the whole year. At that point, there was no carryover, correct?
That's correct. Based on your consumption and subscription that you provided, that's correct.
Okay, so were you listening to the testimony or to my cross-examination and Mr. Bebe's answers to my cross-examination questions yesterday?
I was, but I can't necessarily recite them. You would have to refresh my memory to any specific items you want me to refer to.
Yes. You know what I wanted to highlight for you or have you remember was the discussion about, first of all, PNM's proposal to PRC that it adopt a method for carryover, which entails PNM alerting the subscriber organization at the 6-month point. If the customer has exceeded its subscription, right?
6 of 12 months, I believe, is our proposal. Yes.
Thank you for that clarification. And do you remember Mr. Alaric saying that this was just one method and it happens to be the method that PNM is recommending, but there could be other methods. In fact, Ms. Zur, Stephanie Zur, on behalf of REIA, suggested 1 or 2. Do you remember that testimony?
I do.
Okay.
Would it be helpful for me to explain why PNM is concerned about subscription sizing?
I think it might be helpful, but let me ask you the question, right? My next question is, sizing is between the subscriber organization and the community solar customer in the first instance, right? That's who's going to decide. That's how a size is going to be decided between the SO and the community solar customer, right?
That's correct.
PNM is not involved in that contract, in that subscriber agreement, correct?
That's correct.
And that in your example, even though there were excess credits over 6 months, there was no carryover at the end of that example year, correct, Mr. Sedlich?
That's correct. The example you chose, which is labeled A, was based on the then current rates, not P&M's proposed rates, or not the now current rates either. We've got a lot of rates.
Of course, of course. This is an example, and you already testified what an example is, so I think everybody understood you when you testified in that way. Let me ask you whether you, Mr. Sedlich, as as a witness for P&M, would consider that another approach to this issue, and let me, I meant to preface this line of questioning with what we're talking about here, which is obviously now sizing, the sizing of the subscription and the taking of precautions to prevent oversubscription. That's the topic of, or that's the objective of these questions.
I understand that, yes.
And,
Okay.
and Miss Yee, I just want to let you, I mean, you are at your half hour. I'll let
Oh,
you ask,
no.
I'll let you ask, a couple more questions, but we have a full afternoon this afternoon.
Okay, thank you, Your Honor. Would you consider P&M requiring annual reports from the subscriber organizations about each consumer's consumption for that past year? A reasonable alternative to the approach that P&M is suggesting in its testimony, both in your testimony and Mr. Babet's testimony, and that both P&M and subscriber organizations would take those annual reports and decide whether those subscriptions should be resized.
At this point, I don't want to say any particular method is better or worse than another. What I would say is P&M is definitely interested in further rulemaking that will define exactly how this should work. I think that should be done in a open environment where all stakeholders can be involved. I don't think it should be bilateral between P&M and MPEC or P&M and anybody. I think that should be involve everyone so you can come up with a workable solution. And the reason P&M is concerned about that is we want to make sure that people are not customers are not oversubscribed, because if they are, that would make more bill credits, which could potentially make more subsidy that has to be dealt with. So we are interested in making sure these are right sized according to the statute and the act.
Thank you. So I would like to ask a question, Mr. Hearing Examiner, or two about another topic, but I can make it very quick.
Okay, proceed.
Thank you. Without going into sharing screen and showing the Community Solar Act and so on, do you remember in my cross-examination of Mr. Babet yesterday that we discussed a portion of the consumer? I keep on flipping over that, the Community Solar Act, which is specifically 62-16B, 62-16B-7 B, B, 7B8, which says that the community solar bill credit should comprise certain the qualifying utilities total aggregate retail rate less distribution costs, and provided that non-subscribers shall not subsidize costs attributable to subscribers. And anyway, so that I can not have to ask so many questions, I will ask, do you remember that line of questioning yesterday?
I remember your line of questioning.
And so I want to ask you, Mr. Settlage, as the pricing principal for P&M, and as someone who is familiar with rate cases, because I personally had the pleasure and privilege of being in some of those same rate cases that you were in, right? You are familiar with rate cases, aren't you?
I am.
And that you're very familiar because you are a lead witness, expert witness for P&M on rate design and how rates should be on rate design, right?
I'm an expert witness on rate design, yes.
And so you know, Mr. Settlage, because about the principle of cost causation, and that rates are designed in such a way that the costs are allocated to each customer class as they cause them. Are you familiar with that principle?
I am familiar with the principle of cost causation.
And so that in each rate case, the commission is looking at the costs overall and looking at those costs as they're allocated to the customer classes, and those costs would include operations and maintenance, administrative costs, and also the right to earn a fair rate of return on its capital investment. Is that a fair rendition of rate making?
I think that's fair. There's one slight component you didn't have in there, and that is what we call the banding, where we take the cost-based cost of service and the commission adjusts that or asks us to adjust it for various social or other reasons, societal reasons, so that some rate classes may get more or less than their true cost-based allocation. But that's called the banding process, and that's what is then used to develop the rates, that banded class cost of service.
What's that last word you're saying? I can't hear you.
I'm sorry, banded class cost
Oh,
of
yeah,
service.
that was in the 2016 case, 261. And Stella Chan testified about that to avoid rate shock, right? To avoid rate shock. Is that right?
And other things. The commission approves the banding for their objectives, their societal objectives, rate shock being one of them, I'm sure.
But each rate case is looking at the costs that are incurred by the public utility in a test year, correct?
That's correct.
And it could be historical or it could be future, correct?
The rate cases I'm familiar with at P&M have all been based on a future test year.
So these are the costs that the Community Solar Act is talking about, right?
I'm not sure I quite follow that, but I will say that the way that the credit is calculated is based on those same costs that are from the rate case, yes.
Okay, thank you. I think I definitely abused any privilege that was extended for time, and I am sorry, Mr. Mueller, but that concludes my questions.
Yeah, that complete.
I did move those into evidence, so I think I'm good.
Yes, you did. All right, that completes cross-examination of the witness, Mr. Williger. Any redirect?
Yes, hearing examiner, thank you. Just to pick up where we left off, Mr. Settlage, you had a lengthy discussion with Ms. Yee about rate making. You recall that?
Yes.
Can you tell me, and for purposes of calculating the community solar bill credit, based on P&M's most recently approved rate case, how the commission determined that rates should be set for the case and how that flows through to the bill credit calculation?
Yes, I think at a high level, they approved an overall cost of service broken out into different categories. And then they approved a banding process to allocate to each class. So we ended up with a approved class cost of service. That is what is taken and used to develop the actual rates that were approved, that banded class cost of service the commission approved. And then, based on that, we calculate the bill credits based on that. Should I go into more detail about the specifics of that?
Now, I'll just ask you an open-ended follow-up question here. So for purposes of calculating the bill credit and different components of the bill credit, like the distribution component, what does PNM use based on the rates that were approved, what does PNM use to calculate that bill credit, including like the distribution component?
Okay, so we start with the total demand and energy rate. Sorry, we start with the
Mr.
total.
I'm
I'm sorry, I apologize. Oh,
We start with the total demand and energy.
Objection, oh, I'm gonna object that it's outside the scope of cross-examination.
I'm gonna allow him to answer, but I'll monitor where we're going with this.
So we
You
start
can
with,
answer.
oh, sorry, I apologize for stepping on you. We start with the total dollars in that demand and energy, total demand and energy dollars, which includes demand, energy, and other things. Divide that by the class energy to come up with a rate that is the demand and energy rate. Then to calculate the TAR, we subtract out a portion of that demand in that demand charge, that minimum demand charge, for instance, and also the customer charges, and subtract that out to end up with what's known as the TARR, TAR. So we're subtracting out some of the demand charges, but not all of the demand charges, I think is the key point here.
I renew my objection.
I'll
Yeah.
move on. I'll move on. You had a few questions, a fair number of questions from Mr. about the minimum demand. You recall that?
Yes.
And she walked through an example with you. If the minimum demand on a certain rate schedule, like rate schedule 4B, is 500 kW, and that's what the customer uses in the month, she asked you a question of whether that customer is getting a credit for their demand costs pursuant to the Community Solar Act and the Community Solar Rules. Can you explain whether or not that customer is getting a credit, still getting a credit if we exclude demand charges from the calculation of the TAR?
If we exclude the minimum demand charges, they're still getting a credit for the TAR that includes the rest of the demand charges. It just doesn't include the minimum demand charges. There are more demand charges than just the minimum.
Okay. You had several questions. You and Mr. Schlesinger kind of talked about the regulation and how the calculation of the TAR is at length. Do you recall that?
Yes.
And I think you went through 17.9.573 subsection 20 subpart B.
I believe so.
At
Yes.
length. Yeah, that's the total aggregate retail rate. Sorry for the court reporter. I'm just going to try to not use acronyms here. And you and Mr. Schlesinger were talking about that the TAR does not include charges described on a qualifying utilities rate schedule as minimum monthly charges, including customer or service availability charges. Do you recall that discussion with him?
Yes, I do.
Can you explain to me where you think the minimum monthly demand charges fall? Are they a customer charge? Are they a service availability charge? Can you explain to me what your thinking is in terms of that minimum monthly demand?
I think that's a service availability charge, just like the customer charge is.
Can you explain why?
Yes, I mean, the rate schedule defines these components, and we're supposed to collect them from the customers. The Act also specifically says we should exclude these from the calculation of the credit.
I mean, why is it a service availability charge?
Because these are related to the customer being there regardless of their consumption. having the service available is what the driver for these is, not that they're a big user or a little user or have a high demand or a low demand. This is the minimum charges.
All right, thank you. You also talked at length with Mr. Schlesinger about the aggregate retail rate and that you used the aggregate retail rate to determine the subsidy. You recall that?
Yes.
And specifically, you noted, or he asked you a question because it's consistent with your testimony about that you used how you determined the R was based on your professional judgment. You recall that?
Yes.
Can you just explain why you used the aggregate retail rate to determine the subsidy, and in your professional judgment, what you determined that aggregate retail rate should be?
The act says to use the ARR. I'm trying not to say R either, but the ARR. I mean, it's in black and white. It says to use that. And when I look at that, I use my judgment to come up with what I think that means. The way I selected that, not including the fuel and renewable portions, which vary regularly, not including those gives a more stable, transparent number that doesn't vary until we have another rate case. So it helps provide transparency and stability to those rate credits.
And in your discussion with Mr. Schlesinger, you talked about how PNM has, based on hearing from Mr. Barnes, CCSA witness Barnes, about how to calculate the subsidy cap, that PNM has agreed to sort of modify its position on that. Is that right?
That's correct. We agree with witness Barnes that using the system as a whole is more appropriate because it's more transparent and it's simpler.
So you're not calculating the subsidy on a class by class basis anymore. You're calculating you're agreeing with Mr. Barnes to calculate it on a system basis. Is that right?
That's correct. Yes, on a system basis.
And given what you just discussed about stability, and having a stable subsidy cap, does your PNM's changed position on using the system to determine the subsidy, does that relate to your concerns about having a subsidy cap that is stable and predictable?
Yes, the way we originally proposed it could potentially change as customers in different classes subscribed, and using the system as a whole avoids that. So it's very simple, very transparent. We don't care where the subscribers are, what classes they're in. They'll get the credit, and the cap will be calculated the same regardless. And further, we proposed using ARR as I've defined without those two riders, which change on a very regular basis. The fuel changes at least 4 times a year, and the renewable rider changes twice, and they don't all change on the same date due to the way the billing system works. So using an ARR makes a much more stable and transparent, and it's much simpler calculation. So it sort of plays into some of witness Barnes' concerns with PNM's proposal, or his purported desires. This is a more stable and clear way of doing that.
Okay. One last question. You and Mr. Schlesinger talked about your this is in your rebuttal, PNM table MJS1 rebuttal at length. Do you recall that?
Yes.
It's on page 21 of PNM Exhibit 6. Do you recall that?
Yes.
And in particular, you walked through, well, what is this table? Can you just, so I'm not asking you a leading question here. What is this table? What does it show? And how does it relate to PNM's position now?
So this table, MJS1 rebuttal, shows a calculation of the subsidy cap based on not using the ARR as PNM proposes, but using the TARR as witness Barnes suggested. It also shows another difference between our current proposal, and that is this was done using only customer classes with subscribers, and PNM now believes it's much more appropriate to use the system as a whole to calculate that.
Okay, thank you. And so in your discussion with Mr. Schlesinger, you talked about how this was just illustrative and that when we actually look at the subsidy, that's going to be cost. It will be cost, including the bill credits and avoided cost to actually determine that subsidy. Do you remember that?
Yes, that's what would be compared to the subsidy cap.
So what is PNM, just to walk through that and clarify that for the record, tell me how PNM is going to determine the subsidy in its subsequent rate case and its proposal to recover those costs.
Yes, so we will look at what we're going to record the total bill credits in a regulatory asset. And I believe we asked for that regulatory asset in the most recent rate case, 22-00270 UT, but the final order was silent on that. And I should have mentioned this earlier, I suppose. I think of it now. We would like to ask for that regulatory asset in this case to record those total bill credits. What would also go in that regulatory asset is any other costs we identified that are related to this, so that when we have a subsequent rate case, we can make a proposal and the commission can rule on whether those were appropriate to include in that, appropriate to include in the recovery of this subsidy.
And at that regulatory asset, would you offset that regulatory asset with any identified avoidable cost?
Yes, yes. Again, this example just lists bill credits, but there are also some cost charges that go the other way as well. So it's going to be that net number, whatever that is, and we'll have to figure out what that is. We don't know at this time. We don't even have any facilities built yet.
Okay, that's all my questions. Thank you for the indulgence, hearing examiner.
Okay, thank you. Witness is dismissed.
Wait, hearing examiner?
Yes,
Sorry,
Ms.
I
Sierra.
had my hand raised. First of all, I apologize for my coughing and interrupting you earlier, Ms. Terwilliger. I'm coming down with a cold here. But I would like to ask, if you don't mind, one clarifying question, because it sounded like Mr. Sutledge gave Ms. Terwilliger an opposite answer to the same question I asked. And I can tell you what that is if you want to know, or
I was pretty specific this morning that I'm not going to allow recross to the extent, I mean, there are some issues that have been posted today that I will ask for in briefing, so you can point that out to me at that time. But we have 3.5 hours to fit into the next 3 hours, so I'm going to ask that you raise that in briefing.
all right, thank you.
All right. Up next, we have SPS. SPS, are you and your witness ready to proceed?
We are, Your Honor, and as an initial matter, SPS has converted the Excel hearing exhibit documents to PDF and uploaded those yesterday into the Dropbox per your instruction.
Okay, thank you.
And we would call Ms. Zoe Lees.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon. Could you please state your full name for the record, Ms. Lees?
Yes, Zoe E. Lees.
And by whom are you employed and in what capacity?
I'm employed by Southwestern Public Service Company as Regional Vice President of Policy and Planning.
And do you have in front of you a document that's marked as SPS Exhibit 1?
I do.
Could you identify that document for the record, please?
This is the Phase 2 direct testimony of Ruth M. Sakia, which, as corrected by SPS's errata notice, which was filed on November 28th, 2023.
Is it your understanding that SPS filed a motion for leave to substitute witnesses in this proceeding?
It is my understanding, yes.
And is it accurate that you adopted a portion of Ms. Sakia's testimony, as did Mr. Trowbridge?
That is correct.
Do you also have in front of you a document that's marked as SPS Exhibit 2?
I do.
And do you could you identify that for the record, please?
Yes, that is the Phase 2 rebuttal testimony of Zoe E. Lees, my rebuttal testimony.
Do you have any corrections to that testimony today?
I have one correction. On page 35, On line 10, the first 3 words of that line, community solar program, should just say utilities.
So the sentence as corrected would read, starting on line 9, it is inappropriate to expect that utilities
Yes, correct.
subscribers. Absent that correction you just made, is your testimony true and correct to the best of your knowledge?
It is.
And if you were asked the same questions today, would your answers be the same?
It would.
Your Honor, SPS moves for the admission of SPS Exhibits 1 and 2.
Request is for SPS Exhibits 1 and 2 to be admitted onto the record. Any objection? Hearing none, they are admitted.
And we would tender Ms. Lees for cross.
Okay, for Ms. Lees, I have NEE for 25 minutes. Mariel?
Thank you. Good afternoon, Ms. Lees. My name is Mariel Nanasi, and I work with New Energy Economy. How
Good
are you
afternoon.
today?
I'm well, thank you.
You're an attorney, is that right?
Correct.
SPS is a subsidiary of Xcel Energy. Is that right?
Correct.
SPS, along with the other investor-owned utilities, PNM and EPE, appealed the commission's community solar rules. Is that right?
SPS did appeal those rules, correct?
And SPS filed a motion to stay implementation of the commission's community solar rules, right?
I recollect that.
And 2 days ago, the New Mexico Supreme Court denied that motion. Is that also right?
The New Mexico Supreme Court did deny our motion to stay.
SPS Exhibit 2 is your rebuttable testimony. And could you, I'm referring to page 8, but I want to ask you, you believe it's your testimony that using uniform methodologies for calculations, recovery mechanisms, and categories of administrative costs among the utilities may be possible and also may be a benefit to the commission. Is that right?
Yes, I testify that where the utilities are able to align and create uniformity, SPS does see value in continuing, and SPS does see value in continuing the discussions to try and reach that uniformity.
And it also might be a benefit for subscribing customers as well, correct?
It could be.
You would agree that as a general matter, the commission wants to approve methodologies that are sufficiently transparent, correct?
My understanding of the scope of this proceeding is what is stated in the March 1st procedural order. And beyond that, I can't say what the commission's goals are for the proceeding.
You don't believe that the commission wants to approve methodologies that are sufficiently transparent?
It's not that I disagree with that. I just can't speak for the commission.
I'm asking you about SPS's position. Do you believe that it is the commission's goal to approve methodologies that are sufficiently transparent?
Objection.
Basis of the objection?
Asked and answered and straying into argumentative. Ms. Lees has already indicated and answered. Ms. Nanasi continues to ask the same question.
I'm gonna agree that witness has answered it of her understanding. If he could proceed with questioning, Ms. Nanasi.
Thank you. And when when implementing community solar rules, especially the costs that are being recovered from them under the community solar program, let's strike that. And when implementing the community solar rules, the costs for the community solar program should be easy to explain and understand for subscribing customers. Is that correct?
Can you repeat the question? I'm sorry, you started with an and I'm not sure what that and was referring to. So can you restate the question?
When implementing the community solar rules, the costs that are being recovered from subscribers should be easy to explain and understand, and should be as easy to understand as possible, correct?
SPS believes that it has put forward a cost recovery method that is transparent in this case.
What is the total number of megawatts SPS has on its system for use in New Mexico?
Oh, I don't have the exact number, Ms. Nanasi, around 5,000 megawatts, but that's an estimate.
The total megawatt cap for SPS in the community solar program is 55 megawatts, correct?
I believe that's correct.
In your rebuttal testimony, you state that any potential avoided costs are purely speculative at this time and may not be realized. Is that fair to sum up your part of your testimony?
Ms. Nanasi, I need to correct my previous answer. It's 45 megawatts per the rule.
Okay.
And can you repeat your question?
In your rebuttal testimony, you discussed that any potential avoided costs are purely speculative at this time and may not be realized. Is that correct?
I believe that's the gist of my testimony. And if you can point me to the page that you're referring to, that would be helpful.
Is that because utilities have continued to block the implementation of community solar?
No.
SPS has experience with community solar in Minnesota.
SPS does not operate in Minnesota.
Excel has experience with community solar in Minnesota, right?
Excel's operating company, Northern States, Minnesota, does provide service in Minnesota, yes.
Isn't it true that the community solar program in Minnesota has resulted in 426 completed projects with 830 total megawatts of operational sales?
Objection.
Basis of the objection?
Outside the scope of Ms. Lee's testimony, there's no foundation laid absent that.
Mr. Nanasi, are you referring to a certain part of testimony that you could direct me to?
Yes, I am. I believe that Ms. Lees complains that New Energy Economy makes accusations about the performance of, well, around that, actually, I'm going to get into that. But basically, what I'm trying to bring up is that on page 12 and 13, Ms. Lees discusses that the avoided costs are purely speculative. And the fact of the matter is that in many places in the United States, when community solar has in fact been allowed to be implemented, that there's been a huge uptake, and that SPS's parent company, Excel, is extraordinarily familiar with that, because in Minnesota, they have at least 426 completed projects with 830 total megawatts. And I'm going to ask about others as well. And I think it's relevant.
Okay.
Your Honor, Mr. Nazi is testifying.
Hold on. I'm going to allow the witness to answer the question, because I am seeing that she refers to the New Mexico community solar requirements are not the same as the requirements in Colorado and Minnesota in her. So is it, Ms. Nanasi, let me just ask you, is that your line of questioning to ask her what those differences are?
I was going to ask that, but I'm also asking about when Ms. Lees, I believe that I could go into this for impeachment, says that the potential avoided costs are purely speculative, but that's not true.
Okay, I'm going to allow the line of questioning to the extent that she wants to elaborate on why the requirements are not the same, and I'm going to limit the line of questioning in regards to impeachment, but the witness can answer the question, and we'll kind of take it from there.
Thank you. So, do you know that Excel has 426 completed projects with 830 total megawatts of operational sales in Minnesota?
I know that there are community solar projects in Minnesota.
And do you know how many there are?
I do not.
Do you know that there are hundreds?
I do not know how many there are.
Do you know how many megawatts approximately they are?
I do not.
And you said you were the vice president of regulatory? Is that right?
I'm regional vice president for SPS, for policy and planning.
And what about in Colorado? What's the total number of megawatts of community solar installed in Colorado?
I do not know.
Do you know how many projects have been completed in Colorado?
I do not.
Do you know that Massachusetts, New York, and Minnesota lead nationally for installed community solar and have many, many hundreds of completed projects and combined thousands of megawatts of operational sales from community solar?
I am not aware of that.
What's the difference between the Minnesota community solar program and New Mexico's community solar program?
I don't know what those differences are between the two programs. I'm focused on the implementation of SPS's program in New Mexico.
And do you know, well, have you done any comparisons between New Mexico and Colorado?
I have not.
But you're the regional director, right?
I'm the regional vice president for SPS, correct?
What is that? What encompasses that region?
Texas and New Mexico.
Is it your testimony that qualifying utilities have no responsibility to ensure a positive customer experience for the community solar under the community solar rule?
My testimony is that our proposal, our proposal addresses a positive customer experience, but that it is not solely our responsibility.
Is SPS a responsible party, though, to ensure a positive customer experience?
It is SPS's responsibility to implement the program pursuant to the statute and the rule.
And does that include ensuring a positive customer experience?
Objection.
Basis of the objection?
Asked and answered, and again, straying into argumentative when Ms. Lees has already provided the answer 3 times.
I'll agree that Ms. Lees has answered the question. Let's continue on, Ms. Nanasi.
What are the uneconomic costs of energy delivered by community solar projects to the SPS system?
My testimony doesn't address that. Mr. Trowbridge can better answer those questions.
Didn't you say on page 14 specifically, line 15, you specifically say, while the community solar program has value to subscribers, it also has associated costs, including the uneconomic cost of energy delivered by community solar projects to the system. That's your testimony, right?
That's correct.
So what do you mean by that?
I mean, what it says. in
Well,
the
could you please
testimony.
elaborate?
Yeah, the
What are
question,
the uneconomic costs?
Mr. Trowbridge discusses what those uneconomic costs are in his testimony, and those are the costs for which I refer to here.
And so is it your testimony that you don't know what the uneconomic costs are?
It's my testimony that the uneconomic costs are identified by Mr. Trowbridge, and that is what I am referring to there. It's costs. I'm not as eloquent as Mr. Trowbridge in explaining it.
In 2013, the commission adopted a quality service plan tariff in Minnesota. Is that correct?
I do not know.
On page 40, you accuse New Energy Economy of making generalized assertions about utilities. Is that right? And disparaging the utilities conduct?
I believe this sentence you're referring to says NEE makes generalized assertions about utilities and their attitude or perspective on community solar, but provides no evidence of such conduct.
And isn't it true that in February 2021, the Minnesota Commission determined that Xcel had 129 complaints around interconnection, specifically solar interconnection, and ordered that Xcel shall report on the number of interconnection requests received, the number and status of interconnection requests in process, the number of interconnection requests withdrawn and the reason, and the number of interconnection requests successfully completed, and that the reports shall include, at a minimum, a detailed assessment of compliance with required timelines, the number and status of any disputes or complaints, and a description of any work in progress to improve the interconnection process.
I don't know.
Has SPS interconnected any of the solar facilities in its territory in New Mexico?
I don't know. And I don't know what solar facilities you're referring to, Ms. Nancy. The community solar facilities at issue in this docket?
Yes.
I don't know.
How many community solar facility projects were awarded within SPS's geographic territory?
I believe 9 or 10, but I'm uncertain of the exact number.
None of those projects, none of those 9 or 10 projects have actually been interconnected, have they?
Objection, asked and answered.
Did SPS recently inform developers that the interconnection timeline has been delayed for 12 months or more?
I am not aware of that.
I have no further questions.
Okay, thank you. Next request, staff requested 10 minutes. Mr. Black.
Thank you, Mr. Hearing Examiner, and we would like to thank the witness, Zoe Lees. Staff has no questions of Ms. Lees, and we appreciate the ability to have a place marker just in case that changed, but no questions. Thank you.
Okay, thank you. Redirect.
No redirect, Your Honor.
Okay, thank you. Witnesses excused. I believe we were going to do witness Clem next, correct?
That's correct. That's correct. We'll just take a few moments to switch over Ms. Lees and Ms. Clem.
Sure.
Ms. Clem, if you're there, could you turn your camera on? And take yourself off mute. We would call Carrie Clem. She's ready to be sworn in by the court reporter.
Ms. Clem, would you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Good afternoon, Ms. Clem.
Good afternoon.
Could you please state your full name for the record?
Carrie Ryan Clem.
And by whom are you employed and in what capacity?
Excel Energy Services, and I am the Manager of Business Solutions and Results for the delivery of the program aspects of the Renewable Choice Program for portfolio across all Excel Energy jurisdictions.
And in front of you, do you have a document that's marked SPS Exhibit 4?
I do.
Could you identify that document for the record?
It is my rebuttal testimony in this case.
And was that testimony prepared by you or under your direct supervision and control?
Yes.
Do you have any corrections to your testimony?
No.
Is the testimony true and correct to the best of your knowledge?
Yes.
And if you were asked the same questions today, would your answers be the same?
Yes.
Your Honor, SPS would move for the admission of SPS Exhibit 4 into the record.
Request is for SPS Exhibit 4 to be admitted onto the record. Any objections? Hearing none, it is admitted.
And we would tender Ms. Clem for cross.
Okay, for Ms. Clem, first up, I had CCSA, half an hour.
Yes, thank you, Mr. Hearing Examiner. And also, like yesterday, I know that I'm going to want to share my screen again. So will you please enable that?
You should have that ability now.
Thank you. Good afternoon, Ms. Clem.
Good afternoon.
My name is Elisa Greenwald. It's nice to meet you. I'm representing CCSA in this proceeding.
It is nice to meet you as well.
So I'd like to talk to you today about SPS's proposed administrative cost. So let's start at page 5 of your rebuttal testimony, where you describe the unique requirements of the community solar program in New Mexico. So it's your position that these requirements drive the design and implementation of the program. Is that right?
These particular requirements are differences to Minnesota and Colorado that are unique to New Mexico. They are not the only things that we need to do in order to implement the program.
Sure. And these unique requirements in New Mexico are driving some of SPS's administrative costs. Is that right?
That is correct.
Okay, so let's talk about some of those specific unique requirements that you highlighted on page 5. So at lines 8 through 10, you listed the requirement that 30% of the electricity produced from community solar facilities must be reserved for low-income subscribers and low-income service organizations. Do you see that?
I do.
Okay, let me go ahead and share my screen. Okay, can you see that, Ms. Clem?
Yes.
Perfect. Okay, this is CCSA's interrogatory 9-2, which has been marked as CCSA Exhibit 23. And I'll scroll down so you can see, I think there's 3 pages here. And you prepared and sponsored this response, is that right?
Correct.
And is this exhibit an accurate reflection of the response that you prepared? And I can scroll back up for you as well.
Let's see, 9-2?
Yes, 9-2.
Yes.
Okay, fantastic. Let me find section that's relevant here. Okay, so in response to section D of this interrogatory, you admitted that there are projects in Colorado, either in service or under development, where 30% of electricity produced is reserved for low-income subscribers and low-income service organizations. Am I reading that right?
Yes,
Okay. And more specifically, you explained that in Colorado, there are 19 active community solar gardens that have at least 30% of their output allocated to low-income subscribers or low-income service organizations, right?
yes, those particular gardens have those requirements.
Okay. And 21 community solar gardens are in development in Colorado that have committed at least 30% of their output to low-income subscribers and low-income service organizations, right?
Yes,
And then an additional 9 community solar gardens in Colorado have committed at least 30% of their output to eligible income qualified customers, customers located in disproportionately impacted communities, or service providers that serve these customers. Is that right?
yes.
Okay, it was a bit of a mouthful, huh? And I think I know this already, but you have a fair amount of experience with Excel's community solar program in Colorado. Is that right?
A fair amount is an undefined term, but I do have experience with the program.
Okay, sure thing. So would you agree with me that the Colorado rules contain requirements that there must be some minimum level of reservation of community solar capacity for low-income subscribers?
I would have to go back and review those rules to confirm that.
Okay, so subject to check. You would agree?
No,
Or you-
I have to go back and check.
Okay, sounds good. Would you agree with me that Excel has some experience with tracking participation of low-income customers?
Yes, though it is a manual process.
Okay. I'm gonna go ahead and keep screen sharing so we can discuss another one of the unique requirements that you listed. So on lines 4 through 5, on page 5 of your rebuttal, you also list the use of a third-party administrator to select and enforce certain aspects of the program as a requirement unique to New Mexico. Is that right?
As a requirement, that is unique.
Okay. And for the Legacy Community Solar Garden Program in Minnesota, Excel previously administered its own program. Is that right?
Yes, Excel previously administered all aspects of that program under regulation.
Okay. Let me scroll up to section A here. And here you explained that while Minnesota's community solar program historically did not have a third-party administrator, the legislature decided to sunset the legacy program and to establish a new program with the Minnesota Department of Commerce as the third-party administrator. Is that right?
Yes,
Okay. And Excel also previously administered its own community solar program in Colorado. Is that right?
yes, and it continues to do so today.
Okay, so looking at your response to section B of this interrogatory, you explained that for the 2023 RFP, a third-party independent evaluator will review RFP terms and operational practices of the RFP process. Is that right?
That is correct.
Okay, and prior to bringing on the third-party evaluator for the 2023 RFP, would you agree with me that the Colorado Commission had expressed some frustration with the administration of the program?
I do not recall specifically.
Okay, yeah, no worries. We can clear that up in briefing. Mr. Hearing Examiner, at this time, I move to admit CCSA Exhibit 23 into the record.
Request is for CCSA Exhibit 23 to be moved onto the record. Any objection?
No objection.
It is admitted.
Thank you. All right. So now that we've discussed those New Mexico program requirements, let's get into the administrative costs. So table 1 on page 8 of your rebuttal testimony shows SPS's revised administrative cost budget. Is that right?
I need to quickly look through to find their table, but subject to check.
Yeah, okay, sounds good. And let me give you a minute. Tell me when you're there.
Okay. Yes, I can confirm that it is on page 8.
Okay, thank you, Ms. Clem. And the revised total budget for 2024, including program management and labor from 2023, is $842,860. Is that correct?
Yes.
Okay, share my screen again. Okay, can you see that?
Yes, I see hearing exhibit 24.
Okay, yep, this is CCSA interrogatory 4-8, which has been marked as CCSA exhibit 24. And let me scroll down for you. Again, I think there's 3 pages here. Now you prepared this exhibit alongside Ruth Sakya, is that right?
Correct.
And is this an accurate reflection of the response that you prepared? And here, let me scroll it for you.
Yes.
Okay, thank you. Now looking here in section B, there's a table that describes the Solar Rewards Community Program's administrative costs and fees for Northern States Power in Minnesota. Am I characterizing that table right?
Yes.
Okay. And under the column for the...
What? Sorry, can I go back?
Of course, Ms. Plum, go ahead.
All right. That is the costs, not the fees.
Yes, thank you for the clarification. Okay, so looking at the column for the years 2014 through 2018, the table shows that the total program administration cost over this 4-year period were $3,297,594. Is that right?
Yes.
Okay, and if we were to divide that figure by 4, we come to about $824,000 for the 4-year period. Does that sound right?
Without doing the math, subject to check.
Subject to check for an attorney who went to law school to avoid doing math, but yes, thank you. Okay, so would you agree that that figure, 824,000, is pretty comparable to the 842,860 figure that SPS estimates for its 2024 budget?
Yes, it seems that it would be.
Okay. SPS was allocated 45 megawatts for the initial phase of the program. Is that correct?
That is correct.
Are you aware that?
Yes, I think it's 45, 44
Okay.
or 45, roughly.
I believe Miss Lee's confirmed that too, so I think we're on the same page.
Great.
Yep. Okay, so are you aware that PNM was allocated 125 megawatts for the initial phase?
I have read that in the rules.
Okay. So you would agree that PNM was allocated significantly more capacity for the initial phase of the program?
Yes.
Are you familiar with PNM's administrative cost proposal?
No.
Okay, no worries. Mr. Hearing Examiner, at this time, I move to admit CCSA Exhibit 24 into the record.
Request is for CCSA Exhibit 24 to be admitted onto the record. Any objection?
No objection.
It is admitted.
Thank you. All right, so let's turn back to that same table, table 1 on page 8 of your testimony. You would agree that the majority of the 2024 budget can be attributed to the one-time application development and maintenance cost. Is that right?
Yes.
And to be clear, this category, one-time application development and maintenance, that includes the technology system upgrades, right?
Yes.
Okay. And the portion of the upgrade costs attributed to the online portal itself is $450,000. Is that right?
As estimated, that is correct.
Okay. And to be clear, this $450,000, that's part of the $600,000 that SPS estimates in upfront technology costs?
Yes.
Okay. So along these lines, you would agree that the online portal is the largest portion of the upfront IT costs?
Yes.
Okay. So turning to pages 23, it's the bottom of page 23 and the top of page 24. I'm looking at lines 16 through 17 and then 1 through 2. Yep, tell me when you're there.
23 and 24.
Yep.
Which lines, please?
16 through 17 on page 23 and then 1 through 2 on page 24.
Okay.
All right, so here you discussed that the development of SPS's online systems is expected to require significantly less effort than other jurisdictions have required due to the ability to reuse architecture and code. Is that correct?
Yes,
And you also have online portals for the other jurisdictions in which Excel has community solar programs, right?
yes.
And these online portals are based on the same underlying technology platform?
They're based on the same core system of Salesforce.com, and then they're architected separately on top of that core system.
You know what, Ms. Klim, can you repeat the very last bit of that? My audio went out for a moment.
Oh, yeah, they're coded or architected.
I'm still not getting audio from you.
Are others also having this issue?
I can hear you.
I can
I
hear
can
you.
hear you loud and clear. So it looks like we're having a speaker issue on Ms. Greenwald's part, perhaps.
I'm back with audio. Could you just repeat the last part of your answer, please? I'm so sorry.
Could you repeat the question so that I can keep it fresh in my head as I respond?
Yeah, absolutely. I think I asked you if all of those online portals were based on the same underlying technology platform.
Yes, they are all part of a Salesforce.com customer relationship management system, and then they're coded or architected separately within that system.
Okay. So starting on page 19 of your rebuttal and then continuing through page 20, you list the specific functions that must be built into the online portal for the New Mexico program. Does that look right?
Yes.
Okay.
Although it is not a all-inclusive list. We are still in the process of building out requirements and determining what all the functions need to be, in part pending the outcome of this proceeding.
Understood. Among the list of functions that you provided within your rebuttal testimony, the only one that you note as unique to New Mexico is the transfer of subscription data into the billing system and correctly applying the subscriber fees to subscriber bills. Is that right?
I'm just reviewing this because I've never considered the content in that context. So please give me a moment.
Yep.
The data privacy authorization process also is likely to be different due to the subscriber consent and disclosure form, which is unique to SPS as well.
Noted.
Going through to finish.
Okay.
That's one that I noticed. Of the items listed, those are the two that are unique to SPS.
Okay, so 2 total based on what you reviewed here.
Yes, of
Okay.
what was listed.
Yes, thank you, Ms. Clem. So if less effort is required to develop these systems, given the existing code and architecture, this should presumably result in some cost savings. Is that right?
Yes, compared to if we had started from scratch and had to contemplate every single decision and operational practice and the core code to create those functions.
Sure. Okay, I'm going to go ahead and share my screen again. Can you see that?
Yes.
Okay, this is CCSA Interrogatory 9-9, which has been marked as CCSA Exhibit 25. And I will scroll for you. I think this one's only 2 pages. You sponsored this exhibit, is that right?
I did sponsor this exhibit.
And is this exhibit an accurate reflection of the response that you sponsored?
Yes.
Okay, so looking at section C, you state that you haven't been able to determine the exact savings resulting from reusing existing components. Is that right?
Yes.
And you have not, through testimony, provided a forecast of these cost savings. Is that right?
That is correct.
Okay, so today you aren't able to provide any testimony as to exactly how much SPS expects to save from the ability to reuse the existing online architecture and code.
That is correct, because it would require going through the requirements once they're fully built out and estimating what it would have been, what the cost would have been to develop that from scratch. So any sort of cost savings estimate would be purely hypothetical.
Sure, understood. So no estimate today.
No.
Okay. Mr. Hearing Examiner, at this time, I would move to admit CCSA Exhibit 25 into the record.
Request is for CCSA Exhibit 25 to be admitted onto the record. Any objection?
No objection.
It is admitted.
Thank you. Okay, I have two final exhibits that I'd like to go over with you quickly. I don't have any substantive questions on these, but I'd like to get them in the record because I think they're helpful clarifications. So I think we can get through these really efficiently. Okay, you should be looking at CCSA Interrogatory 9-3, which has been marked as CCSA Exhibit 26. And this is one page. You prepared and sponsored this response, is that right?
Correct.
Is this exhibit an accurate reflection of the response that you prepared?
Yes.
Thank you. At this time, I move to admit CCSA Exhibit 26 into the record.
Request is for CCSA Exhibit 26 to be entered on the record. Any objection?
No objection.
It is admitted.
Thank you. Okay, one more. This is CCSA Interrogatory 9-4, which has been marked as CCSA Exhibit 27. And you prepared and sponsored this response as well, is that right?
Yes.
And is this exhibit an accurate reflection of the response that you prepared?
Yes.
Okay, at this time, I move to admit CCSA Exhibit 27 into the record.
Request is for CCSA Exhibit 27 to be entered on the record. Any objection?
No objection.
It is admitted.
Okay, with that, thank you so much for your time, Ms. Clem, and I have no further questions.
Thank you.
Okay. Thank you. Next for Ms. Clem, I have NEE, Ms. Nanasi.
Thank you. Good afternoon, Ms. Clem.
Good afternoon.
You heard some of the questions that I asked Ms. Lees, correct?
Correct.
So I wanted to see if you had familiarity with some of the questions that she didn't appear to know. So could you tell us how many megawatts has resulted from the community solar program in Minnesota and how many projects that there are?
Objection.
Basis of the objection.
Compound question.
It is a compound question. However, I think it's just covered by asking the witness her knowledge of programs in Minnesota. So I'll allow her to answer as to the Minnesota programs.
So the number of megawatts, last I checked, was 890 megawatts online, but I don't have a memorization of the number of projects.
Is it correct to say that there are more than 400?
Subject to check. It depends how you define a project as well.
And in Colorado in total, do you know how many megawatts of community solar has been installed?
Subject to check, I believe it is close to 150 megawatts.
And would you say that in both Minnesota and in Colorado, that as a result, there were avoided costs that Xcel experienced as a result of those projects?
I don't know.
Do you know about the Minnesota Commission's finding against Excel in February 2021?
I would need you to elaborate on that.
That there were 129 complaints against Excel for solar interconnection issues. And in February 2021, the commission agreed that those should be made part of the record and that there had to be remedial action taken.
I don't have specific knowledge of the regulatory components of that because I do not work in our regulatory group.
But you do know about that proceeding, just in general?
At a very high level.
Has SPS interconnected any of the solar facilities in its territory in New Mexico?
Can you please repeat the question?
Has SPS interconnected any of the community solar facilities in its territory in New Mexico?
No.
How many community solar facility projects were awarded within SPS's geographic territory?
I don't know the exact number, but I believe it is between 9 and 11.
Did SPS recently inform developers that the interconnection timeline has been delayed for 12 months or more?
I do not know.
I have no further questions. Thank you so much.
Thank you. Next, staff, you reserved 5 minutes. Mr. Black, do you have any questions?
No questions today. Thank you.
Okay, thank you. Redirect.
No redirect, Your Honor.
Okay. Witness is excused. Thank you.
And Mr. Mueller, Ms. Clem does have to leave now for an engagement after she is excused. So if she does need to be recalled or anything, it would have to be tomorrow.
Duly noted. Thank you.
Thank you.
Your Honor, we do have one more witness, and Ms. Hardy is going to be sponsoring that witness. So we'll have a witness change and an attorney change.
Okay, thank you.
Would this be a good time for a break?
Yeah, we've gone for 2 hours. So in accommodating the break, why don't we take a 10-minute break because we're almost back on time to finish by 5 here. So let's go ahead and take a 10-minute break, or 12 minutes. I've got 2:58, so we'll go back on the record at 3:10. Okay, I have 3:10, so let's get everyone back. Madam Court Reporter, are you all set? All right, let's go back on the record. SPS, present your next witness, please.
Thank you, Mr. Examiner. SPS's next witness is Alexander G. Trowbridge.
Mr. Trowbridge, would you unmute yourself, please? Would you raise your right hand for me? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Trowbridge, can you please state your full name for the record?
My full name is Alexander G. Trowbridge.
By whom are you employed and in what capacity?
I'm employed by SPS as the manager of pricing and planning.
Do you have in front of you a document that's marked as SPS Exhibit 3?
I do.
Can you please identify that document?
This is my rebuttal testimony in this case.
And was that testimony prepared by you or under your direct supervision and control?
It was.
If you were asked the questions in your rebuttal testimony today, would your answers be the same?
Yes.
Thank you. Mr. Examiner, I move the admission of SPS Exhibit 3.
Let me just, before I ask that question, we also have the Excels and the PDFs as I requested marked as Exhibit 3. Are we looking to move all those onto the record at this point, Ms. Hardy?
Yes, Mr. Examiner.
Okay. Request is for SPS Exhibit 3 and accompanying documents to be moved onto the record. Any objection? Hearing none, they are admitted.
Thank you. Mr. Trowbridge is available for cross-examination.
Okay, first up for cross-examination, I have CCSA.
Thank you, Mr. Hearing Examiner. Good afternoon, Mr. Trowbridge. We've met before, but my name is Jake Schlesinger. I'm representing CCSA today. It's good to see you again.
Good to see you.
So mostly we're going to be talking about your rebuttal testimony today. You may or may not need to refer to it. But first I want to talk about your position that there should be no subsidy from non-participants in the community solar program. That is your position, right?
Yes, that is what the company has proposed.
Okay. Are you aware of any other programs that SPS runs which you would characterize as creating subsidies between participants and non-participants?
I can't think of anything offhand in particular.
Okay. Does SPS offer net metering service to its customers?
The company has a net metering program.
Do you consider net metering to create subsidies between participants and non-participants?
I haven't offered a position on that in my testimony.
Okay, but I'm just asking if you have a position on it.
I haven't analyzed that.
Ever?
For the purpose of my testimony here, I haven't done any analysis of distributed generation net metering programs in SPS and whether or not they cause subsidies or to what extent they might cause subsidies.
Okay. Do you know whether SPS has ever taken the position or whether Xcel Energy has ever taken the position that net metering creates subsidies between participants and non-participants?
I'm not familiar with what SPS has done. I know that generically that that there's been concern about subsidies with net metering.
Okay, so there has. Okay. Would you agree with me that community solar is generally designed to allow customers, even those who may rent or may not have suitable sites to install on-site solar, that it allows them the opportunity to participate in distributed generation? Would you agree that's one of the points of community solar?
I think that that may have been one of the thrusts for community solar, but with that regard, the purpose of my testimony is to offer the pricing alternatives, essentially to comply with the statute and rules in implementing the program.
Okay. Xcel runs community solar programs in other states like Colorado and Minnesota. You're familiar with those programs, yes? Generally, that they exist?
I'm familiar that they exist, and I don't know the details of those programs in particular.
Okay. Do you believe that either of those programs, Colorado or Minnesota, creates subsidization between subscribers and non-subscribers?
Mr. Examiner, I'm going to object. Mr. Trowbridge just said he wasn't familiar with the details of those programs.
I tend to concur with that. I can pretty much predict his answer based upon his previous response.
May I respond?
Mr. Schlesinger?
Thank you. I think I can ask some additional foundational questions to make this question, to lay the proper foundation, if you would like.
Yeah, because we're based upon his previous answer, we're reaching at this point. So proceed with your other foundational questions.
Okay. Mr. Trowbridge, you joined SPS in September of just this past September, right? 2022?
That's correct.
And prior to that, since 2009, you worked for Xcel Energy and Public Service Company of Colorado, the Xcel subsidiary, or I'm sorry, the Colorado subsidiary?
That's correct.
Okay, so in your 13 plus years at Xcel Energy and specifically at Public Service Company of Colorado, did you have any opportunities to interact with the community solar program there?
Can you clarify interact with the solar program?
Did you work on any regulatory filings that had anything to do with community solar in Colorado?
I did.
Okay. So you have some familiarity with the Colorado Community Solar Program?
I do have some familiarity. That wasn't very recent. And the scope of issues that I may have been dealing with may not deal with subsidy issues. So I may not have argued subsidy issues. I may not have analyzed subsidy issues.
Sorry, you may not have, or you didn't?
I don't believe I did.
You don't believe that you did? Did you provide testimony in Public Service Company of Colorado's 2019 Renewable Energy Plan about calculating avoided costs and doing res, no res modeling?
That sounds familiar.
And didn't that testimony involve the costs and potential subsidies between renewable energy programs in Colorado, between subscribers or participants and non-participants?
The scope of my testimony here in SPS did not focus on my work in PSCO. I don't have that testimony available, and I'm not sure how it's germane, but I could attempt to answer questions about res, no res.
Okay, I don't have any questions for you about that, but were you serving as an expert witness in that Colorado proceeding that we just discussed?
Yes,
And are you serving as an expert witness today?
I am for SPS and the implementation of the community solar program here.
Okay, and as an expert witness, do you think that your understanding of the market, especially markets in which you've worked before, is relevant to the veracity of your arguments?
I'm gonna object to that question as being confusing.
I'll withdraw the
Okay,
question.
thank you.
I'm sorry. It was argumentative, I think is what you were looking for. So let me move on. Let me try to re-ask the question that I originally asked again, now that we've laid some foundation. Do you believe that the Colorado Community Solar Program creates subsidies between participants and non-participants?
I didn't analyze subsidies between participants and non-participants.
Sure, and I'm not asking you for the results of an analysis. I'm just asking you for your opinion. You know that there are bill credits in Colorado. You know how they work. You know how they get treated from a rate perspective, don't you?
I do.
Okay, so just based on your professional opinion as an expert, can you answer the question?
So I didn't take any opinions about subsidies in Colorado. I believe that based on my experience, I think that there are several different positions amongst parties as to whether or not subsidies exist on particular types of costs, for instance.
Okay, I'll move on, but let the record reflect that the witness did not answer the question that I asked him. Let me just ask you as a general matter. You are an expert on rates generally, right? You just said you are.
I would agree with that.
Okay. So would you agree with me that sometimes there are subsidies that exist between various rate classes, say residential and commercial? Just in general?
The term subsidy, I mean, I would need you to define what subsidy you might be talking about. And I just don't know generically what you're referring to.
I'm using the term subsidy in the exact way that you're using the term subsidy. So I'd like you to use your own definition for the term subsidy. Do subsidies exist within rates as between rate classes ever?
I mean, I think generically, I think that arguments can be made. An argument can be made that certain classes may be subsidizing other classes.
Okay. And within certain rate classes, would you agree that subsidies exist between different users within the class, like low users and high users, or low load factor users and high load factors?
I would.
I'm sorry.
I would agree.
You would agree that some subsidies occur regularly within rates?
Yes, within classes and within between individuals within classes.
Okay, so so subsidies, as you define it, are not uncommon in the electric utility industry, right?
I can agree that that pricing is imprecise. It attempts to avoid subsidies between groups, between classes of customers, but it does exist.
Okay. I'll take that, I guess. Okay. Next, I'd like to talk about SPS's proposal to recover the uneconomic portion of the energy costs associated with the company's community solar program. which you propose to directly assign to subscribing customers through the BCCR, or the Bill Credit Cost Recovery Mechanism, right?
Correct.
Okay, and your proposed BCCR specifies the terms and conditions under which SPS will collect the portion of the community solar program credit costs from subscribers that are necessary to avoid subsidization of the program by non-subscribers, right?
Correct.
Okay. And when you refer to program credit costs, you're referring to the cost of providing bill credits, right?
No, not entirely. So the company has proposed an economic screening to identify the level of costs which are considered economic or uneconomic. The uneconomic portion of costs, the bill credit amount in excess of the day-ahead LMP, that's the uneconomic portion.
I'm sorry, Mr. Trowbridge, but that's not the question that I asked you at all. I mean, I understand that you're talking about economic and non-economic costs and how those are recovered, but the BCCR that you proposed, you stated in testimony, and you can look at it, it's on end of page 7, bleeding into page 8. You state that it'll collect the portion of community solar program credit costs from subscribers, right? That are necessary to avoid subsidization. And so I'm just asking.
Yes, I'm sorry. So when you added the portion of bill credits to avoid subsidization, you completed that question. So that's accurate.
Okay. And so within what I just read, when we talk about credit costs, you're talking about bill credit costs, right? The cost of providing bill credits.
No, I mean, I wouldn't characterize it that way. I would characterize the bill credit costs that need to be collected as the amount that is considered uneconomic through the screening process that I was introducing.
Oh, but I thought that you're recovering a portion of the bill credit from the subscriber, and the economic portion would not be recovered. Is that not what you just said?
The formula for what will be recovered, what the company has proposed to be recovered through the bill credit cost rider, is the uneconomic portion of the bill credit.
Okay. And you propose that the economic portion of the bill credit be defined as the Southwest Power Pool's day-ahead locational marginal price.
Correct.
Right? Okay. And I'm going to refer to that as DALMP. Is that how people refer to it?
Yes, I think that's.
Okay. Didn't know if there was some simpler acronym. And the DALMP, according to you, is what represents the avoided costs of community solar, right?
Correct.
And the DALMP is also the compensation rate that is offered to wholesale providers of energy on the SPP market, right?
Correct.
Do you know whether the DALMP on the wholesale market is available to all generators, or is it only available to certain generators like renewable energy generators?
Generically, to the extent that a generator is registered with SPP, it would be allowed, and so it is not renewable generation only.
Okay. And then the costs that exceed the DALMP, those are what you call uneconomic costs, right? Or non-economic costs?
Uneconomic, yeah.
Okay. And those are the costs that you're proposing will be directly charged to the subscribers, everything above the DALMP.
That's right. That's the company's proposal.
Okay. So isn't it correct that SPS is essentially proposing to limit compensation to community solar to just the DALMP, essentially, when you net everything out.
The proposal by the company is that community solar, through this process, right, determining whether there's a subsidy or not, if non-participants are to avoid subsidization of the energy, then it is the company's proposal that the energy should be compensated at the day-ahead locational marginal price.
Okay, understood. And subscribers will get that bill credit at the day, essentially at the day-ahead locational marginal price, as you just stated. And then in addition, they'll also be paying for any approved administrative costs, correct?
Correct.
Okay, so the net effect to the customer after paying for admin costs is actually to receive compensation at something below the day-ahead locational marginal price, right?
Correct.
Are you familiar with what is a qualifying facility under the Public Utility Regulatory Policy Act of 1976?
I'm broadly aware, yes.
Okay, and do you agree with me that PURPA, the acronym for what I just said, requires utilities to pay QFs at their avoided cost, QF being qualifying facility?
Yes, that's correct.
Okay. And isn't it correct that SPS offers large qualifying facilities that elect to register in the SPP market to be compensated also at the DALMP?
That is my understanding. Depending on how the units are registered, either with the company or with SPP directly, they may be compensated at real-time locational marginal pricing as opposed to day ahead.
Okay, great. That's good clarification. Thank you. And those qualifying facilities, they don't pay any administrative costs for community solar, do they?
No.
They don't pay any administrative costs for the running of the QF program to the extent that there are costs there, do they?
No, they don't.
Okay. So then actually, wouldn't you agree with me that the payment that SPS is proposing for community solar is less than what's offered to large qualifying facilities?
I would agree with that.
But you would agree with me that the Community Solar Act requires compensation to retail customers at the total aggregate retail rate minus a number of other things, right?
So I would disagree with that. I believe that the statute and rule requires the development of the bill credit to be based on the TAR less several items, distribution system costs, service availability charges, et cetera. And then that is just a step toward the implementation of what the legislation has, or what's in legislation and rules.
Okay. I assume that's your non-legal layman's opinion, or I apologize. Are you a lawyer?
I am not a lawyer.
Okay. Do you know whether most community solar facilities would qualify as QFs under PURPA?
I don't.
You don't know?
I do not know if community solar gardens or programs would qualify as QFs. If that was your question.
It was my question, but we can move on. Okay, so notwithstanding your position that there is, or that no subsidy should be allowed, the commission may nevertheless determine that some subsidization is in the public interest, correct?
Can you ask that question again, please?
Sure. Under the law, the commission may determine that some subsidization of community solar subscribers is allowed. It's allowed.
I agree.
Okay, thank you. And if they do make that determination, then your position is that SPS proposes to recover those costs, the costs that are below 3%. Or I'm sorry, I think it's the costs that are above 3% through its current RPS rider.
No, you had that correct the first time. So
Yeah.
it's the company's position that if the commission decides that subsidization is appropriate, that those costs should be collected through the RPS rider. That what would be allowed to be collected would be subject to a 3% threshold.
Okay. All right. And assuming that the commission made that determination, it would be necessary for them to determine how to calculate what the 3% cap is for each of the utilities, right?
Yes.
Okay. And SPS estimates that the annual incremental cost of the program is approximately $3.5 million, and the annual estimated cap of the program would be $19.9 million. Is that right? And that was at page 13, line 7 of your rebuttal.
Yeah, let me just confirm in my testimony. So I didn't get those numbers exactly, but I think that's right.
Okay. So for now, SPS estimates that the cost of the program will remain under the estimated cost cap quite significantly, right?
Yes.
Nevertheless, you suggest that the commission may want to refrain from having non-subscribers fully subsidize subscriber costs during the pilot, so that a more accurate representation of the ongoing program costs is conveyed to subscribers in anticipation of an expanded program. You stated that at page 14, line 9.
Yes, that is my testimony.
And when you refer to the pilot, you're referring to this initial allocation of community solar that's already been allocated?
Yes.
And is it your expectation that the commission is going to expand that program beyond the initial capacity?
It is my expectation that the program may expand, that this pilot may lead to an expansion of the program. But then beyond a general expectation, I don't have a basis for how the program will be sized in the future.
Sure, that's fair. I mean, nobody knows at this point, right? It could go either way. Right.
Generically, yes.
Okay. And so given these unknowns, it's actually not possible to provide customers with an accurate representation of future program costs, is it?
The concept that I put into my testimony about trying to limit the amount of subsidy given to participants to allow for a larger program doesn't have confines that are set to it. So it doesn't have bounds from which we would be able to determine at what level something like that could be carried out.
Sorry, I don't think I quite understood your answer. I'm just confirming that without knowing what future capacity may or may not be approved, it's not possible to actually send customers any precise signal of what's to come, right?
I would agree that without coming up with an assumption or an estimate, that we could not do that. Yes.
Okay. All right. Thank you. Are you familiar with Mr. Barnes' proposal that only future community solar subscribers that cause the 3% cap to be exceeded, say by joining a community solar garden that causes the cap to be exceeded, that only they would be assigned and be responsible for paying incremental costs above 3%.
Can you restate your question? I'm following you, but I need to just hear that one more time.
Sure, no problem. Are you familiar that what I just described is Mr. Barnes' proposal?
Can you point me to that area of testimony?
I'm not sure I can, because I didn't actually write down a page reference for that one thing. And of course, that's what you asked me. So let's just move on and we can refer to Mr. Barnes' testimony. It'll be in the record. So let's move on. You understand that Mr. Barnes is also recommending that the commission use what's called the RIM test, or ratepayer impact measure test, to evaluate the benefits and costs of community solar?
Yes.
And would you agree with me that the RIM test measures what happens to customer bills or rates due to changes in utility revenues and operating costs that are caused by a particular program?
I don't know that I have a complete understanding of the RIM test.
Okay. But you oppose the use of the RIM test, right?
I did.
Even though you don't have a complete understanding of it?
There were enough elements in my research of the RIM test. I felt that there were several elements that ignored, for instance, cost recovery for the utility. And then also the RIM test is more commonly aligned with energy efficiency programs. And so I didn't think that it was an appropriate fit with the community solar garden program.
Okay, but you just stated a moment ago that you're not really familiar with the RIM test, but then you just stated that you did research it and look at it and provided an opinion on it, right?
Mr. Examiner, I'm going to object. I think the witness has answered these questions.
Yeah, I think your statement stands on its own, Mr. Schlesinger, if we could move along.
Okay, will do. Thank you. So yeah, I'd like to explore those two reasons that you just gave, and we'll take the second one first. One of the reasons that you explained that you oppose the use of the RIM test is because you believe that it is more commonly associated with demand-side management programs and energy efficiency programs, which you believe are different from community solar, right?
Yes. And Jake is frozen for me, Mr. Schlesinger.
He is the same for me as well. Jacob, you might want to try stopping your video. You might have low bandwidth there. All right. It looks like we have temporarily lost Mr. Schlesinger. We'll just wait a minute to see if he joins back here.
Mr. Hearing Examiner, I'll try to reach out to him right now via text and see if I can get an update real quick.
Mr. Hearing Examiner, just wanted to let you know Mr. Schlesinger is trying to reconnect right now. He's working on it.
Okay, there he is.
Am I back?
You are back. We can see you and hear you.
I apologize for the glitch in the matrix there, Mr. Hearing Examiner. I don't know what happened. I just lost my connection for a moment.
Those glitches happen. Let's proceed.
Okay, what was the last thing that you heard, Mr. Trowbridge?
You were going to ask some additional questions about the rim test.
Okay, and specifically, I'm going to ask some questions about your reasons for opposing the rim test. One of which is because you believe that the rim test is more commonly associated with demand-side management programs and energy efficiency programs, which you state are different from community solar, right?
Yes.
Okay. Would you agree with me that community solar avoids the need for SPS to procure energy? Or I'm sorry, let me restate that. Would you agree that community solar avoids the need for SPS to produce or procure energy?
Let me just think about that a little bit. I think that community solar has the ability to offset the requirements. And in that way, it could avoid future generation investments.
Okay, I'm not asking about future generation capacity investments. I'm asking about whether community solar avoids the need for SPS to produce or procure energy, say, for example, from the SPP market.
I can agree with that.
Okay. And in fact, that's why you propose the day-ahead locational marginal price at the SPP market as the proxy for avoided energy costs, right?
Yeah, I can agree with that. I can agree with that.
And you would agree with me that DSM programs are also designed to reduce PNM's need to produce or procure energy, right?
Yes.
Okay. You also note in your rebuttal testimony that energy efficiency programs are typically coupled with various forms of compensation to utilities to encourage them for what is in effect a reduction of sales, which you term their core product. You recall that?
I do say that in testimony, yes.
Would you agree with me that the community solar program essentially provides subscriber organizations the ability to produce clean energy and provide it directly to customers?
Can you state that question again?
Sure. Would you agree with me that the community solar program essentially provides subscriber organizations or developers of solar energy to produce clean energy and assign it directly to customers?
I don't believe that it's assigned directly to customers. I don't believe that the energy produced is assigned directly to customers. At least the way that I understand your question.
Okay. Would you agree with me that the energy from a community solar community solar facility is allocated to subscribers? Does that work better?
No, I would not agree with that.
You would not. Okay. Mr. Hearing Examiner, I'd like to share my screen if that's okay.
Yeah, you should be able to do that now.
Here we go. Mr. Trowbridge, I've put up on the screen here, New Mexico statutes 62-16B-2. You see that?
Yes.
Okay.
Could you zoom a little bit for me again? Thank you.
Thank you.
And I can provide a clarification.
Okay, please do. Well, since we have a written record here, let me just note that we're looking at the definition of community solar bill credit. And the statute states that community solar bill credit means the credit value of the electricity generated by a community solar facility and allocated to a subscriber to offset the subscriber's electricity bill. You see that?
Yes, I do.
Okay. So would you agree with me?
So
let me just ask my question again, so we have a clear record. But now that you've seen that, would you agree with me that community solar is allocated to customers or subscribers?
The credit value is credited to subscribers, allocated to subscribers. The credit value, which is different than the energy.
Okay. Yeah. And I understand your distinction. Would you agree with me that community solar leads to a reduction in sales for the utility?
No, I would not.
You wouldn't?
No, I would not.
It doesn't lead to lost revenues for the utility?
It does not. Not under the company's proposal.
Ah, okay. Thank you for making that clarification. Okay. Do you know if there are any performance incentive mechanisms in New Mexico that provide compensation to utilities or specifically to SPS to encourage them to reduce carbon emissions?
I'm not closely familiar with some of the programs. So, I mean, I maybe just ask your question one more time.
Sure. And I honestly don't even know the answer here, which is, rule number one that I'm breaking for cross-examination. But I'm asking you if you know whether there are any incentive mechanisms that the New Mexico Commission or the legislature has approved that allow SPS to be compensated if they achieve carbon reduction goals or renewable energy goals.
I'm not familiar with any incentive mechanisms in SPS to compensate the company for reaching carbon reduction goals.
Are you aware of similar types of mechanisms in other jurisdictions?
Not offhand.
Not offhand. Did you work on Public Service Company of Colorado's most recent electric resource plan?
Public Service Company?
Yes.
I did file testimony. So it's been over a couple of 2 years ago that I participated in one of the last resource plans.
Yes, for me as well.
Okay. And I know that there have been some other stages, but I think that is probably the most recent resource plan.
Do you recall whether the company or any interveners discussed or considered performance incentive mechanisms related to carbon reduction or renewable energy production?
I don't recollect.
Okay. Do you think SPS could propose such a mechanism in New Mexico if it wanted to?
I think they could propose a mechanism like that.
And the commission would probably have the authority to approve it. Do you know?
The commission has broad authority, and it could include a incentive plan of that sort.
Okay. You also claim in opposing the RIM tests that community solar facilities do not promote energy efficiency or reduce net load in the way that energy efficiency programs reduce load. And you assert that, on the contrary, community solar facilities are in theory added to serve future load. You recall that?
I do.
But isn't it, I'm just about to ask you the same question, which you already answered. I apologize. And wouldn't you agree with me that the subscriber subscribes to a subscription which has to be sized, or which is limited to no more than 100% of the subscriber's annual energy average? Sorry, let me restate that. Isn't it true that subscribers can sign up for a subscription so long as it does not exceed 100% of their annual average energy consumption?
Yes, that's my understanding.
You also state at the bottom of page 19 of your rebuttal testimony that no test suggests that the utility's recovery of embedded costs should be ignored in evaluating the public interest, which includes the utility. You recall that?
I do.
And so are you suggesting that the RIM test does not account for the utility's embedded costs?
My understanding of the RIM test and Mr. Barnes' assertions were that no subsidy exists when if the utility was disallowed cost recovery. And part of the subsidy finding is based on a public interest finding, and a public interest, and that is to make the point that the utilities are also part of the public interest. So if the utilities are harmed, then it becomes a measurement of public interest.
Okay. But do you take the position that the RIM test fails to account for utilities' embedded cost? Is that one of your criticisms of why we shouldn't use the RIM test?
I believe that the RIM test, from my research of the RIM test, I think that there is an assumption. So there are, this may be a little bit more detailed answer.
Yeah, and honestly, you know, Mr. Hearing Examiner, I'm just asking to try to understand his position. He said he opposed the RIM test. He said utility embedded costs shouldn't be avoided in that section of his testimony. So I'm just trying to understand if he's claiming that the RIM test doesn't allow embedded cost recovery. Is that your position? Is it not your position? Did you take no position on that matter?
It's my understanding that the RIM test ignores disallowed embedded cost recovery because it will be recovered at some point in the future by the utility. That's essentially my understanding.
Okay. Would you agree with me that the RIM test measures what happens to customer bills or rates due to changes in the utility's revenues and operating costs caused by whatever program is being evaluated?
That's my understanding.
And aren't utilities rates designed to recover the utility's entire existing rate base?
Generally, yes.
And wouldn't that include the utility's embedded costs?
I think lost revenue is ignored as a concept of the RIM test in defining benefit. And so that's where I add in my testimony a discussion that energy efficiency programs, DSM programs, typically attempt to compensate or provide bonuses to go through and offset that impact to the company.
Okay. You reviewed Mr. Barnes' testimony in preparing your rebuttal testimony, right?
I reviewed Mr. Barnes' written testimony.
Okay.
But I can't say that I've committed it to memory. I think there's 500 pages of attachments that are in there. So
Sure. Let me refresh your recollection here. So this is Exhibit JRB5, which was attached to Mr. Barnes' testimony, which is the California. Oh, geez. I'm going to forget the name of it. But did you look at this?
yes, I did. So it is one of the tests that are included in the California Standard Practice Manual.
Correct. And this page is about the ratepayer impact measure test, which is the test that we're talking about, right?
Right. It's one test, one of the other tests, right? So in my testimony, I talk about.
I'm sorry, I'm not asking you about the other tests. I just want to ask you about this test. And you just testified, sir, that the RIM test does not account for lost revenues. Do you recall saying that?
Yes.
Okay. Can you please read what I have, this paragraph here that has the highlight in it, just to the end of that highlighted sentence? Or the sentence that contains the highlight? You can let me know when you're finished.
Okay.
Okay, so after refreshing your recollection with this manual, would you agree with me that the RIM test accounts for the cost of decreased revenues for any periods in which load has been decreased by the program?
I do read that, but I don't have an interpretation of that.
Okay, that's okay. Thank you. Okay, your proposal does not seek to account for any potential future avoided capital investments that community solar might avoid, correct?
Correct.
Nevertheless, you did acknowledge in your rebuttal testimony at page 21, line 8, that there is no doubt that DERs, such as community solar facilities, may have benefits, including the ability to avoid future generation, transmission, and distribution facilities. You recall that?
I do.
So if a community solar were shown in the future to have avoided a generation, transmission, or distribution facility or facilities, wouldn't today's community solar subscribers be subsidizing future subscribers who might benefit from those avoided costs?
No, I don't think so.
Okay. Getting back to your BCCR proposal for a moment, you noted that if community solar facilities are compensated for energy at a higher rate than market price of electricity, the utility has to pay more for the solar energy than it would for other sources of power. You recall that?
Yes.
And to be clear, when you talk about market price here, you're talking about the wholesale price or the DLAMP that we talked about before, right?
Right.
Would you agree with me that certain sources of power are more valuable than other sources of power?
Are you referring to renewable energy?
Sure. Could renewable energy be seen as more desirable than non-renewable energy?
I think it could.
Okay. And therefore it could be valued higher, correct?
It could.
Would you also agree to me that there's probably a significant cost, or we already know that there's a significant cost in converting our 100-year-old electric utility system to one that relies on clean sources of power?
Can you repeat that question?
I'm just asking, wouldn't you agree that there are significant costs, significant incremental costs to going green, to shorthand it?
There are significant costs to converting generation to renewable resources. Absolutely.
Okay. In response to Mr. Barnes's proposal in your rebuttal testimony on how to calculate the subsidy, you stated that the concept of trying to quantify every potential avoided cost and externality in assigning reasonable purchase price seems unnecessarily complex, if not impossible. Do you recall that?
Yes.
So you're not claiming here, at least in this sentence, that there won't be a bunch of additional avoided costs in the future, but just that trying to quantify them is going to be difficult. Fair?
I don't believe the compensation for community solar power should be compensated based on avoided costs. That's not how the utility buys energy through purchase power arrangements. That's not how it charges customers through its cost of service. And that's not how prices are determined through an RFP process. The concept of avoided costs helps us to define a threshold at which we would consider approaching in achieving the goals that we have. For instance, bringing on more renewable power. But I don't think that it's a basis for setting the price.
Okay. Would you agree with me that there are other jurisdictions out there, if you're familiar, that do try to do just that do try to quantify avoided costs and future avoided costs and use methodologies like the RIM test in evaluating programs like this?
I'm not familiar with those programs directly.
Let's see. I'm going to try to shorten this up a little bit, Mr. Hearing Examiner. So just give me 1 second to figure out what I need to keep. Okay. Okay. Regarding the method of calculating the subsidization, you noted at page 25, line 14 of your rebuttal that CCSA's proposed method of calculating the 3% cap is not substantially different from SPS's proposal. And that instead of using total customer revenues as SPS proposes, CCSA proposes to exclude customer and minimum charges.
That was my understanding of the proposal. Yes.
Right. So would you agree with me that all else being equal, excluding customer and minimum charges results in CCSA calculating a lower 3% cap than what SPS calculates?
I would agree.
And in fact, Mr. Barnes calculated a cap based on certain assumptions of about $13 million. Does that sound right? I can show you if you need to recall, or we
Yeah,
can...
if you want me to confirm, that would be great.
You don't need to.
Otherwise, that's in the ballpark.
Okay. And yours was about 20 million, correct?
That's right. 19 million.
Okay. Okay, last couple of questions here. Switching gears entirely to talk about admin costs for a moment. And specifically, I want to talk about SPS's IT costs. And I know Ms. Clem had a pretty detailed conversation with my colleague, Ms. Greenwald, about this. But you recommend the amortization period for those IT costs, right?
I do. I presented an alternative methodology where those IT costs were amortized over a period of time to flatten the impact and spread out the cost of that resource over a period of time.
Okay. And your recommendation is that the amortization period be no longer than 3 years for those IT costs, right?
Yes.
Okay. I'm going to share my screen here. And is this zoomed in enough? Is that better?
That's fine. Thank you.
Okay. So this is what's been marked as CCSA Exhibit 22, which is SPS's response to CCSA 9-16, and you're the sponsor of this response, correct?
Correct.
And this looks like the response that you provided?
Yes.
Okay. And so you note here in your response that SPS projects that the expected useful life of the IT upgrades is no longer than 3 years due to potential changes in program rules and requirements. But without program rules or requirement changes, the technology will remain usable for users beyond 3 years. That is your response, right?
Yes, that is the response. And I could probably add to that slightly.
But I'm not asking you to add to it, sir. I'm just asking you if this is the response you provided. I'm just authenticating this docket and then I will move for its admission.
Yes, sir.
Okay. Now I'd like to move for the admission of CCSA Exhibit 22.
Request is for CCSA Exhibit 22 to be admitted onto the record. Any objection? Hearing none, it is admitted.
Okay. So just to be clear, based on this response, you're proposing an amortization period that is not based on the asset's useful life, but rather based on potential future regulatory actions, right?
Carrie Clem is a co-sponsor of this as well, as you can see. She is more familiar with advancements in technology and software, changes in program parameters. And it is based on Carrie's opinion and from our IT professionals that recommended 3-year useful life was developed.
Okay, so again, it's not based on the expected useful life of the IT assets, right?
And I don't really agree with that characterization. This is intended to capture a useful life from a technological standpoint and also from an expectation standpoint in terms of administration of the programs.
Okay. And the expectation that you're referring to is the potential changes in program rules, right?
Yes.
But those are completely unknown at this point, correct?
Correct.
Okay. Thank you. I have no further questions.
Okay, thank you. Next, for Mr. Trowbridge, we have NEE, Ms. Nanasi.
I'd waive cross, thank you.
Okay, thank you. The last party is staff, Mr. Black.
Thank you. Good afternoon, Mr. Trowbridge. How are you?
Good. Thank you, Mr. Black. Nice to meet you.
Nice to meet you as well. Let's see, I have a question about your IT investment cost in your testimony. SPS Exhibit 3, page 32, lines 13 through 17. It's your rebuttal testimony.
Can you clarify the page number again?
32.
Okay. All right, I'm there.
Okay, and my question is SPS now requesting a regulatory asset for IT investment costs?
To the extent that the commission accepts an amortization method for the asset, the company is requesting a regulatory asset to track that value and to record the time value money.
In this case?
In this case.
Okay, thank you. Now, let's see. Yes, that same page, starting at line 17, going over to page 33, line 1, one word. Are you with me?
Yes, I am.
Okay, the question is, for the IT costs, the information technology costs, why do you believe it is best to earn interest at the weighted average cost of capital metric instead of using other calculation methods such as New Mexico customer deposit in interest rate or cost of debt rate?
Generally, I would say that once we get into amortization of the asset as opposed to relatively concurrent recovery, we've changed the asset to be a long-term asset, and the company has financed that asset. The company earns its weighted average cost of capital generally on its utility investments. And that's the basis, as opposed to a debt return or some other basis of return.
Well, that's a good thing if this is a long-term program, right?
Yeah.
Community solar. Okay. Thank you. Thank you so much. No further questions.
Thank you.
Okay, thank you. Any redirect, Ms. Hardy?
No, Mr. Examiner.
Okay. That concludes SPS's witness and SPS witnesses excused.
Thank you.
Thank you.
And that concludes our schedule of witnesses today. We'll begin tomorrow with CCSA and Mr. Barnes. I also want parties to, at the end of tomorrow's session, I'll ask parties about briefing, and if parties are requesting any extension time on that briefing. So everyone look at your calendars in advance, so you're prepared with to answer that question. So I'll make that part of my briefing order if any extensions are requested. Are there any other matters that we need to review before we adjourn for today? Madam Court Reporter, did you need any clarification from today's record?
No, thank you, Mr. Hearing Examiner.
Okay. All right, thank you everyone for staying within your time slots. I'm glad we were able to get everything in today that we needed to, and we are adjourned for today.